Welcome to your daily global legal news briefing for Tuesday, May 27, 2025. I'm bringing you the most significant legal developments from India and around the world that impact business, technology, and legal practice. Today's edition covers groundbreaking Supreme Court decisions, AI liability developments from the US, and critical EU AI Act implementation updates. Starting with our top story from India, the Supreme Court delivered a crucial judgment in Patanjali Ayurved Limited versus Union of India, with major implications for businesses dealing with customs disputes. The court ruled that wrongly invoked bank guarantees can be refunded without the restrictions of Section 27 of the Customs Act or the doctrine of unjust enrichment applying. This HIH precedent value decision clarifies that when customs authorities encash bank guarantees, it cannot be treated as payment of duty. The practical insight here is significant. Businesses can now seek refunds of bank guarantees without having to prove burden transfer under Section 27. This simplifies the refund process considerably for companies in similar disputes across importing, exporting, infrastructure, and banking sectors. Moving to our second Indian development, the Delhi High Court addressed an important limitation issue under the Indo-Swiss Double Taxation Avoidance Agreement. In the case of Principal Commissioner of Income Tax Central 1 vs SMT, Snehalata Sohani, the court held that invalid references cannot exclude periods from limitation under Section 153, Vs. B of the Income Tax Act. The business impact here is that tax authorities must ensure validity of their references to avoid limitation lapses. For taxpayers, especially in cross-border tax matters, this reinforces the importance of scrutinizing the validity of references made by tax departments. This has medium precedent value, but could influence similar DTA disputes. In insolvency news, the Supreme Court has ordered a status quo on the liquidation of Bhushan Power and AMP Steel, pending a review petition by JSW. The liquidation process is now stayed, creating major impact for steel and banking sector creditors. This development highlights how Supreme Court interventions can significantly alter the course of large insolvency cases. Shifting to international developments with major AI implications, a US federal court has allowed a lawsuit against AI chatbot developer Character AI to proceed. The judge held that chatbot outputs may not be protected by the First Amendment, treating AI chatbots potentially as products for tort liability purposes. This raises the liability risks substantially for AI developers globally and provides an early precedent for AI accountability debates. The compliance requirement is clear: enhance risk management and legal review for AI deployment. AI developers must now review product safety measures and legal disclaimers, while legal teams should monitor how their AI products and services are classified. The European Union confirmed its AI Act implementation roadmap yesterday. Guidelines on AI system definitions and prohibited practices will be published within 6 months. The staged compliance deadlines are critical: February 2, 2025, August 2, 2025, and August 2, 2026. This affects all companies deploying AI in the EU, including Indian and global tech firms seeking European market access. High-risk and general-purpose AI models will face new transparency and safety obligations. Companies must align with the EU's AI compliance regime now to maintain market access. In US regulatory news, the SEC's Division of Investment Management will host its annual conference focusing on emerging trends, particularly digital assets and tokenization. This signals continued regulatory scrutiny of digital assets in US capital markets and provides regulatory insights for asset managers and fintech companies. For your compliance calendar, key deadlines this week include GST return filing and SEBI quarterly compliance reports by May 31st. Looking ahead, the EU AI Act's general-purpose AI model obligations begin August 2nd, and the SEC Asset Management Conference is scheduled for June 5th. The emerging legal trend we're tracking is courts and regulators globally clarifying liability and compliance for AI products, with focus on user safety and transparency. This spans India, USA, and EU jurisdictions. The business impact timeline shows immediate heightened compliance for AI and digital assets, with new guidelines in 3 to 6 months, and potential global harmonization of AI safety standards within 12 months. Critical action items for legal and business teams include reviewing AI product and service classifications for liability exposure, preparing for EU AI Act compliance deadlines, and monitoring Supreme Court and NCLAT updates for sector-specific insolvency risks. That concludes today's daily global legal news briefing. These developments demonstrate the rapidly evolving landscape of AI regulation, customs law, and cross-border taxation. Stay informed by subscribing to our channel and the Future AI newsletter on Substack for deeper analysis of AI and legal intersection. Thank you for watching, and we'll see you tomorrow with more essential legal updates.